bail bond posted in the course of a criminal action is effective and binding upon the obligor or obligors until the imposition of sentence or other termination of the action, regardless of whether the action is dismissed in the local criminal court after an indictment on the same charge or charges by a superior court, and regardless of whether such action is partially conducted or prosecuted in a court or courts other than the one in which the action was pending when such bond was posted, unless prior to such termination such order of bail is vacated or revoked, or the principal is surrendered, or unless the terms of such bond expressly limited its effectiveness to a lesser period. Provided, however, the effectiveness of such bond may only be limited to a lesser period if the obligor or obligors submit notice of the limitation to the court and the district attorney not less than 14 days before the effectiveness ends. 4. A justifying affidavit must be subscribed and sworn to by the obligor affiant and must state his name, residential address, and occupation. Depending upon the kind of bail bond which it justifies, such affidavit must contain further statements as follows. A. An affidavit justifying an insurance company bail bond must state I. The amount of the premium paid to the obligor, and I. All security and all promises of indemnity received by the surety, obligor, in connection with its execution of the bond, and the name, occupation, and residential and business address of every person who has given any such indemnifying security or promise. An action by the surety obligor against an indemnitor seeking retention of security deposited by the latter with the former or enforcement of any indemnity agreement of a kind described in this subparagraph will not lie except with respect to agreements and security specified in the justifying affidavit. B. An affidavit justifying a secured bail bond must state every item of personal property deposited and of real property pledged as security, the value of each such item, and the nature and amount of every lien or encumbrance thereon. C. An affidavit justifying a partially secured bail bond or an unsecured bail bond must state the place and nature of the obligor affiant's business or employment, the length of time he has been engaged therein, his income during the past year, and his average income over the past 5 years. That's for a partially secured bail bond.
Yeah, that's why we got it wrong.
And that's it.
Okay. Before you close that out, I will do the first two paragraphs.
My phone is broken, but
I'll try. 5/2020. Except as provided in paragraph B, when a bail bond is to be posted in satisfaction of bail, the obligor or obligors must submit to the court a bail bond in the amount fixed, executed in the form prescribed in subdivision 2, accompanied by a justifying affidavit of each obligor, executed in the form prescribed in subdivision 4. When a bail bond is to be posted in satisfaction of bail fixed for a defendant charged by information, simplified information, or prosecutor's information with one or more traffic infractions and no other offense, the defendant may submit to the court, with the consent of the court, an insurance company bail bond covering the amount fixed, executed in a form prescribed by the Superintendent of Financial Services. 2. Except as provided in paragraph B of subdivision 1, which is what I just read, a bail bond must be subscribed and sworn to by each obligor and must state the name, residential address, and occupation of each obligor. B. B, the title of the criminal action or proceeding involved, and C, the offense or offenses which are subject to the action or proceeding involved, and the status of such action or proceeding, and D, the name of the principal and the nature of his involvement in or connection with such action or proceeding, and E, that the obligor or the obligors jointly and severally undertake that the principal will appear in such action or proceeding whenever required, and will at all times render himself amenable to the orders and processes of the court, and F, that in the event that the principal does not comply with any such requirement, order of process, such obligor or obligors will pay to the people of the state of New York a designated sum of money fixed by the court. So, to recap, for an unsecured bail bond, the justifying affidavit must include the nature and place of the obligor's business or employment, length of time engaged therein, the income during the past year, and the average income over the last 5 years. That was for an unsecured bail bond. The secured bail bond is that stuff Dorothy read. That has nothing to do with any of this. That's why we got the fucking question wrong. This is 530.50. A judge or justice may order bail pending appeal unless the defendant has received a Class A felony sentence or a Class B or C felony sentence defined in Article 130 of the Penal Law, committed or attempted to be committed by a person over 18 against a person under 18. This is a clarification of Rule 1036. Subdivision A says, in cases involving abuse only, the petition and summons shall be served within 2 court days after their issuance. After their issuance. If it cannot be served within that time, such fact shall be reported to the court with the reasons thereof within 3 court days after their issuance. This is so stupid. So that is the thing about the after issuance. So they have to be served within 2 court days after their issuance, and if they can't be served, such fact shall be reported within 3 court days after their issuance, and the court shall issue a warrant. This is only for cases involving abuse where the respondent is not outside the state. Okay, because issuance of a warrant shall not be required where process is sent without the state. Now, B says that they shall be delivered to the person summoned at least 24 hours before the time stated in for appearance. So that's different than after their issuance. Then it says, in cases involving either abuse or neglect, court may send process without the state in the same manner and with the same effect as process sent within the state. In the exercise of personal jurisdiction over any person subject to the jurisdiction of the court under 301 or 302 CPLR, notwithstanding the person is not a domiciliary or resident of the state, where the allegedly abused or neglected child resides or is domiciled within the state, and the alleged abuse or neglect occurred within the state. So you need both of those things. Child lives here, abuse and neglect occurred within the state. Now, in cases involving abuse only, where service of a petition and summons upon a non-resident or non-domiciliary respondent is required, such service shall be made within 10 days after issuance. If service is not effective within 10 days, because it can't be, an extension may be granted upon good cause shown, upon application of any party or the child's attorney. So yeah, it's different for abuse versus abuse and neglect, or neglect.
Okay. Whenever a person receives a sentence of imprisonment, the court that has sentenced such person shall deliver the certificate of conviction and provide notification of the sentence imposed to the Commissioner of Social Services. How I don't remember that, because the certificate of conviction, it's also like the commitment when they go to jail, I don't know. But it's sentence of imprisonment. And I should have known that. 1, 3, and 4?
Yeah, read that one.
Okay. Which, if any of the following are true concerning interim probation supervision, which I do almost every fucking day. 1, the court must determine that the defendant is eligible for a sentence of probation. 2, the DA must consent. And 3,
No.
no. The court may adjourn?
The DA doesn't consent. It's D.
Oh, fuck. I got it wrong again. I fucking got it wrong again. But I know it's not the DA must consent because the judge can say, fuck you, I'm doing this anyway. So I don't even know why I would pick that.
All right, start over. With
Okay.
Which are true.
Okay, which, if any, of the following are true concerning interim probation supervision? 1, the court must determine that the defendant is eligible for a sentence of probation. 2, the defendant must consent. And 3, the court may adjourn sentence to a specified date and order that the defendant be placed on interim probation. In no event may the sentencing be adjourned for a period exceeding 1 year from the date the conviction is entered.
Now, who does not have to consent?
The DA does not have to consent because even if they don't want that, the court can just say, like the judge can just say, I want this done today. Fuck you guys. I'm just doing it. And that's it. Great. In order to establish or modify a support order of another state, a petitioner must first register the said order by sending which, if any, of the following documents and information to the appropriate tribunal of this state. 1, a letter of transmittal requesting registration and enforcement. 2, 2 copies of the order to be registered, 1 certified. 3, sworn statement showing the amount of arrearage. 4, the name of the obligor. 5, obligor's address and social security number, if known. 6, name and address of obligor's employer and source of income. 7, name and address of the obligee and, if applicable, the agency or person to whom support payments are to be remitted. That's it.
Rule 205.43, which I'm not even sure is definitely on the test, but just in case it is. If a willfulness hearing for willful non-payment of child support is going to be had by a support magistrate, at the conclusion of the hearing, it shall issue written findings of facts within 5 court days. If a willfulness hearing has commenced and must be continued, the adjourned date shall be within 7 court days. I know, that's probably why they put it on the test, so they can make easy questions out of it. Okay, so the first thing that this says is a submission by a support collection unit pursuant to 413 shall include the following, which shall be submitted on forms promulgated by the fucking chief administrator. 1, an affidavit from the support collection unit, which I'm going to abbreviate as SCU, with findings in support of adjustment. 2, a proposed adjusted order of support. 3, a notice to the parties of the proposed adjusted order and the rights of the parties, including the address of the court and the SCU. The documents set forth shall be filed with the clerk of the court, so that's the clerk of the family court, within 10 days of mailing to the parties, together with an affidavit of service. Where a written objection is received by the clerk within 35 days, the court shall schedule a hearing upon notice to SCU and the parties. Where no timely objection is received, the court shall sign the order upon being satisfied the requirements of the social services law have been met, and transmit copies to SCU for service on the parties. Absent unusual circumstances, court shall sign the order or dismiss application within 10 business days after conclusion of 35-day period. So now 205.43 is talking about the petition that alleges a willful violation or seeks enforcement of a support order shall be scheduled as soon as possible. Can you read that thing about the 30? I can't even see it. For a first appearance.
Over here?
Yeah, and then next, it's like, what does that say about, just on the other side of it?
30
Date
days?
and family court.
What are you talking about? Where?
The 30 days.
Oh, first appearance, date, and family court. But in no event more than 30 days of the filing of the violation or enforcement petition. B, after service is made, the judge or support magistrate must commence a hearing to determine a willful violation within 30 days of the date noticed in the summons. The hearing must be concluded within 60 days of its commencement. Neither party shall be permitted more than one adjournment to secure counsel, except for good cause shown. On the scheduled hearing date, on the issue of willfulness, the hearing may not be adjourned except for the following reasons.
Okay, now I can see it.
Okay.
The actual engagement of counsel pursuant to Part 125 of this title. 2, illness of a party. Or 3, the catch-all, other good cause. No adjournment shall be in excess of 14 calendar days. If a willfulness hearing has commenced and must be continued, the adjourned date shall be within 7 court days. At the conclusion of a hearing heard by a support magistrate, the support magistrate shall issue written findings of facts within 5 court days.
And this is for willfulness of
Failing to pay child support.
so it's like they
They had the money and they just
purposely
didn't want to
don't-
pay it.
Okay.
Okay, and then it says something about a money judgment, a recommendation about incarceration, specific facts upon the finding of willfulness, a recommendation of a dollar amount to be paid to repay the arrears. I don't even know what the hell it's talking about there, but because if they're going to put the guy in jail, the support magistrate can't even do it. Does that make any sense to you?
No.
Okay.
I hate this.
It shall continue through the confirmation proceeding before the family court judge without further order. I have no idea what the fuck that's talking about. Whatever. Remember, 7 court days for the adjournment, I think. No, 14 days, 14 calendar days for the adjournment. The hearing, oh, no, wait a minute. If the hearing hasn't commenced yet, the adjournment can be up to 14 calendar days. If the hearing starts, the adjourned date has to be within 7 court days. And then if the support magistrate does the hearing, which I'm sure they're going to kick it to him, he's got to issue written findings of facts within 5 court days.
And the hearing has to be done within 30 days. Note the date noticed in the summons, and the hearing must be concluded within 60 days of the commencement. All right, gotta put that down.
A support enforcement agency means a public official or agency authorized to seek 1. Enforcement of orders of support or laws relating to the duty of support. 2. Establishment or modification of child support. 3. Determination of parentage. 4. To locate obligors or their assets. Okay, and to read it directly out of the book, it says, support enforcement, this is actually in 580-102, subdivision 27. Support enforcement agency means a public official, governmental entity, or private agency authorized to 1. Seek enforcement of support orders or laws relating to duty of support. 2. Seek establishment or modification of child support. 3. Request determination of parentage of a child. 4. Attempt to locate obligors or their assets. Or 5. Request determination of the controlling child support order. Proceedings to compel support under Article 4 may be originated in the county in which one of the parties is domiciled or where they reside.
Okay, I'm ready. Which of the following are true? In general, a subpoena requiring attendance or a subpoena ducis tecum shall be served in the same manner as a summons. 2. In general, after a subpoena is served, proof of service need not be filed. 3. Any person subpoenaed shall be paid or tendered in advance authorized travel expenses and 1 day's witness fee. 4. A copy of any subpoena ducis tecum served in a pending action shall also be served on each party who has appeared in the action so that it is received by the parties promptly after service on the witness and before the production of books, papers, or other things. That's right. Because you told me the first one was...
You serve the witness first, then you serve it on the other people. In general, during and after trial, disclosure may only be obtained on notice with a court order from the trial judge.
Notice under Domestic Relations Law Title VII shall be given at least 20 days prior to the proceeding by delivering a copy of the petition and notice to the persons to be served. A guardian lawfully appointed under Article 81 of the Mental Hygiene Law may not: 1. Consent to the voluntary formal or informal admission of the incapacitated person to a mental hygiene facility. They cannot do that. Consent to the voluntary or informal admission of the incapacitated person to a chemical dependence facility. They cannot do that. 3. Revoke any appointment or delegation made by the incapacitated person pursuant to sections 5-1501, 5-1601, and 5-1602 of the General Obligations Law. They cannot do that. 4. Revoke any appointment or delegation made by the incapacitated person pursuant to sections 2965 or 2981 of the Public Health Law or any living will.
But they can, the guardian can authorize access to or release of confidential records. They can also authorize the person to travel or something like that. Something about travel.